Good afternoon and welcome to the first of our 3 webinars in this new series on rural litigation. My name is Stephanie Hepburn. I'm a solicitor in our Dispute Resolution Department specialising in property litigation. As well as commercial litigation, I have a particular focus on rural litigation and work with our wider rural property team to help our clients avoid disputes and resolve disputes. If a dispute does arise, our aim is to resolve this without involving the court. But if litigation is necessary, I have experience in the Court of Session, Sheriff Courts, Lands Tribunal and Land Court.
And I'm Emma DeSaley, a solicitor in our rural property team. Our team deals with buying, selling and leasing all types of property, as well as advice on land and estate management, services, access and title conditions.
We have 3 webinars in this current series and hope to roll out more in the future. Today's webinar focuses on Wayleaves, the second on rural crime, and the series concludes with a webinar on private residential tenancies, current reform and the impact on rural rented properties. Today, Emma is going to start looking at a definition of a Wayleave and will then move on to a fictional scenario, the tale of Archie Pickle, which will bring to life the contentious issues that can arise with Wayleaves and what landowners, managers or agents should be looking out for. We have set the scenario up from the perspective of a landowning client and the queries or concerns they may have. In Archie Pickle's scenario, we'll look firstly at voluntary Wayleaves before looking at necessary Wayleaves, when these will be granted by the court and Scottish ministers and the input landowners can have to this process. I must say we have used a degree of artistic licence in our fictional scenario, and whilst we based it on real life cases we've been involved in, it is a story and has an element of fairy tale attached to it. I'm not sure anyone can be as lucky as poor Archie Pickle in real life. The webinar will conclude with looking at the case of William Tracy Limited against Scottish Transmission plc from earlier this year and whether landowners can obtain compensation if they discover a pipeline or other apparatus has been on their land for a number of years without a Wayleave in place. We'll focus on Wayleaves at telecommunications companies and electricity suppliers. Please get in touch with Emma or myself if you have any questions on Wayleaves from other suppliers. If you have any questions as we go along, please use the box on your screen and we'll deal with as many as we can at the end. Those we can't deal with, we'll try to reply to after the webinar. Now, Emma is going to start us off by looking at a definition of a Wayleave.
Thanks, Steph. So I'm going to focus on the definition of a Wayleave in Scotland and how this differs from other rights over land. Whilst the term Wayleave is almost exclusively a creature of statute, there is no legal definition for a Wayleave, and it is a somewhat flexible concept. Essentially, a Wayleave is a right granted by the owner of land to allow the installation and maintenance of apparatus on their land. These rights are usually in exchange for rent and compensation for damage caused to the land. Wayleaves are most commonly sought by electricity providers and telecoms companies as their networks require to extend across the country. It's also important to explain what a Wayleave is not. Whilst the right created by a Wayleave usually denotes something akin to a servitude, most importantly, a Wayleave is not actually a servitude. In Scots law, a servitude is what's known as a real right, that which is exercisable against the world at large, and allows an owner of land to use neighbouring land for a specified purpose, such as access. Servitudes require both a burdened and benefited property, and, provided the right is actually exercised, the servitude right persists even after the respective owners have changed. We call this the right running with the land, and it will bind successive owners. A Wayleave, on the other hand, is usually formed by agreement. It's personal to the parties concerned, and it will not be binding on successors in ownership, except in certain situations which we'll outline later, once the property is sold. And as we will see, this point can have significant implications. Similarly, a Wayleave is not the same as an English easement, as an easement, which is a right over another's land, also requires 2 distinct plots of land, and to be for the benefit of one of those areas in the same way as a servitude. So Steph is now going to tell us about the story of farmer Archie Pickle.
Thanks, Emma. On the slide there, you'll see our fictional farmer, Archie Pickle, and his farm, Pickle Farm. Archie's farm is large, and over the years he has built up a successful holiday lets business from part of the farm. Archie has recently heard that his neighbour's field has been sold to a housing company for development. As you'll find out, Archie is about to be affected by 3 wayleaves over his farm relating to telecommunications apparatus and electricity equipment. Archie received a visit from a large telecoms company, O3. They explained to Archie that due to development taking place next door, they need to install some apparatus on his land. They would like Archie to grant them a wayleave to allow them to access his land to install, maintain and repair the equipment. Archie is concerned about the effect of the proposed installation on his farm and holiday lets business and wants to know more about his bargaining position in relation to the terms of the wayleave O3 are looking for. Emma, what sort of things should Archie be thinking about? Should he be contacting his land agent, Annie, for advice?
Thanks, Steph. Yes, if Archie has a land agent, they should be the first port of call and they can negotiate the best terms for him. Archie's solicitor will also be able to liaise with his land agent and assist with any title queries or negotiations.
Well, Archie contacts Annie for advice.
Annie tells Archie that the Electronic Communications Code will apply to O3's request for a wayleave. The Electronic Communications Code came in under the Telecommunications Act 1984 and applies to the whole of the UK. The code was previously known as the Telecommunications Code and is often still referred to as that. The code is intended to allow electronic communications networks to be installed and maintained and provide certain rights to the providers of those networks. It is designed to facilitate the installation and maintenance of electronic communication networks. It gives rights to providers of these networks to install and maintain apparatus in, over and under land. The code has recently been reviewed by the England and Wales Law Commission and they have brought forward proposals for change and the UK government have consulted on a draft bill which would apply to the whole of the UK. Last summer, the UK government said that they would bring forward a bill in this Parliament, but they have not yet done so. Annie explains that because O3 are an operator in terms of the code, and remember we're using a degree of artistic licence in this webinar, paragraph 2 of the Electronic Communications Code requires O3 to obtain agreement from Archie before access can be taken. Specifically, an operator must obtain agreement from the landowner before they can do any of the following. Firstly, execute any works on the land in connection with the installation, maintenance, adjustment, repair or alteration of electrical communications apparatus. Secondly, keep electronic communications apparatus installed on, under or over that land. And thirdly, enter the land to inspect any such apparatus, whether on, under or over that land or elsewhere, for the purposes of that operator's network. Annie explains that O3 will prefer to agree a voluntary arrangement with Archie. She has dealt with O3 before and explained their standard terms to Archie in return for him granting the wayleave. Archie mulls these over and decides, because O3 only want to install a small amount of equipment, which won't cause any disruption to his holiday lets business, he is happy to grant the wayleave on O3's standard terms. Archie wonders if there are any other general conditions that apply when O3 are exercising their rights under the code. Steph, can you talk us through these, please?
Yeah, so the Electric Communications Code, Conditions and Restrictions Regulations 2003 impose certain general conditions on that O3 must comply with in exercising their powers under the codes. For example, if we're going to put apparatus underground, there is an obligation to ensure that it is installed at a depth that will not interfere with the use of the land unless Archie has consented. Also, it must be installed, insofar as reasonably practicable, in such a way to minimise the impact on the visual amenity of properties, to minimise potential hazard posed by the apparatus, and to minimise the interference of traffic. Archie is concerned about the safety of having overhead lines near a shed on his land, as he is worried about accidents, so he is glad to hear the code operator has an obligation to inspect and maintain the apparatus and to investigate if Archie reports it is in a dangerous state.
This gives Archie some reassurance and he is minded to grant the wayleave. However, he is keen to recover his costs in doing so from O3. Steph, would you have much luck?
Well, unfortunately, the code does not include any provision that would allow Archie to recover his costs from O3 as of right. However, Annie explains to Archie he can insist on O3 meeting his costs as part of the terms of granting the Wayleave. Archie is happy with this, and Annie successfully negotiates his costs from O3, and the Wayleave is granted. All is well on Pickle Farm. Archie is happy with the terms of the Wayleave. Whilst O3 does not have to give him any notice before accessing the farm, they have undertaken to do so where possible. O3 also has to warn him if they are bringing heavy machinery onto the farm. Archie also receives an annual amount of compensation in return for granting the Wayleave. It places an obligation on Archie not to place or build anything on the farm which would interfere or make it difficult for O3 to get to their apparatus, and Archie accepts this. The Wayleave also states that he or anyone he is responsible for must avoid damaging the apparatus. This includes by planting trees whose roots may interfere with the apparatus. On the other hand, O3 agrees to cause as little damage as possible to Pickle Farm and to repair any damage that they do cause to Archie's reasonable satisfaction. Archie is also delighted that Annie got his expenses. The next door development is built and O3 comply with the Wayleave. Even after a bad storm one night which damages their apparatus, they are quick to come out and repair their equipment, and Archie is happy farming away and focusing on his holiday lets business. A couple of years later, Archie hears that a neighbouring field is sold to the same developer to extend the development next door. Archie isn't immediately concerned, but soon O3 come knocking on his door again. They want to install further equipment and would like Archie to voluntarily grant them a Wayleave. Archie will not cooperate. Emma, are there any things that Archie and Annie should be looking out for at this stage?
Well, Annie explains to Archie that paragraph 5 of the Electronic Communications Code would allow O3 to obtain a court order to dispense with any voluntary arrangement and impose the arrangement on Archie. Archie wonders what this would involve. Steph, can you tell us?
If Archie refuses to grant the voluntary Wayleave, O3 simply need to give Archie notice of the rights and or the agreement that they require. That notice must be in a form approved by Ofcom and sent to Archie by recorded delivery. If Archie does not give the required written agreement within 28 days of getting the notice, O3 can apply to the court for an order conferring the proposed right and dispensing with the need for any written agreement.
Archie mulls this over. He wonders whether he can get better terms from O3 for granting them the Wayleave that they need. Annie tells him there are often special circumstances where a landowner can negotiate their own terms. Examples of these may include where the apparatus severely affects the enjoyment of sporting rights on agricultural land, or where there will be interference with irrigation equipment or other specialist operations. Archie tells Annie that he feels he has a good case for seeking increased terms, and so Annie suggests that she negotiates with O3 on his behalf. However, after weeks of negotiation, no agreement is reached. Steph, what happens next?
Well, as expected, O3 served the notice referred to in paragraph 5 of the Code. Archie still refuses to grant the Wayleave, and O3 apply to the Sheriff Court.
Must the court grant the order?
The court must make the order if it is satisfied that any prejudice caused by the order is capable of being adequately compensated by money or is outweighed by the benefit to those whose access to an electronic communications network or services will be secured by the order. In looking at the extent of the prejudice and the weight of the benefit, the court must have regard to all of the circumstances and the principle that no person should unreasonably be denied access to an electronic communications network or to electronic communication services. This has been referred to as the overriding principle. As mobile networks have developed, it's often more difficult nowadays for the operator to prove the site is required to achieve proper network coverage. However, the case of Legger-Davy against the First Secretary of State suggests that the court does not have to pay regard to the fact that there are other sites locally that are available or are more suitable for the equipment. The Sheriff Court therefore grants O3 a right to install further equipment on Archie's farm.
And what terms does the court attach to this?
While the court can decide the terms of the order, for example, it can determine the extent of the rights granted to O3 and the practical requirements attaching to these rights. It must also include such terms and conditions as appear appropriate for ensuring the least possible loss and damage is caused to Archie by O3's exercise of their rights. The order should also provide for payment by O3 of fair and reasonable compensation, as if a Wayleave had been given willingly. Adequate compensation is also required for any loss or damage caused by O3's exercise of the rights granted by the court order. Whilst case law has established this compensation shall not amount to a capital or ransom payment, unfortunately there is very little other case law which provides guidance on how the courts will actually exercise these powers in practice. It's not all bad news for Archie, however, as the court orders the rights can only be exercised by O3 across a specified route which is far away from his holiday let business. The court also grants Archie a fair and reasonable rent and compensation in the event O3 damage his land by exercising their rights.
Archie accepts all of this. He realises that it would cost him more time and money in taking matters further with O3. He ploughs on and focuses on his holiday lets business, which is booming. The further development on the neighbouring field progresses and, hot on the tails of O3, Archie is approached by Tartan Power, an electricity company who want to install electric lines and associated equipment such as poles, pylons and transformers on his land. They ask him to grant a Wayleave for doing so. Archie is concerned about all of these companies taking access all over his land and the impact on his farm and business. What right do they have to do that? Once again, Archie approaches his trusted land agent, Annie. Annie explains that Tartan Power is an electricity licence holder under the Electricity Act 1989, and remember again, we're still using our artistic licence here. They have general duties contained in Section 9 of the Act to develop and maintain electrical distribution and to facilitate the supply of electricity. They operate under a statutory regime which gives them compulsory acquisition powers to enable them to comply with their statutory duties and obligations. Annie explains that Tartan Power will be seeking a voluntary arrangement with Archie, which feeling they may promote a CPO order. Annie also reassures Archie that, as a licence holder, Tartan Power do have certain obligations to abide by when taking access over his land.
Archie also asks Annie if there are any other powers that Tartan Power may exercise if he is unwilling to grant him a voluntary Wayleave.
Well, they may apply for a necessary Wayleave. Steph, can you tell us more about this?
Unlike with telecoms, where the application is to the court, with a necessary electricity Wayleave in Scotland, the application is to the Scottish Ministers under Schedule 4 of the Electricity Act 1989 by the electricity provider for the necessary rights they require. It is usual but not mandatory for licence holders to try to negotiate a voluntary Wayleave first before invoking this more formal Wayleave process.
Archie is interested to hear this, and Annie puts him in touch with a solicitor to learn more about necessary Wayleaves. Steph, can you tell us more about what the necessary Wayleave is, please?
Yes, so a necessary Wayleave is a statutory right which confers powers on the licence holder, in this case it would be Tartan Power, to install their electric lines and equipment on, over or under private land, to keep the electric line there and to have access to that land for the purpose of inspecting, maintaining, repairing, adjusting, altering, replacing or removing the electric line or equipment. The necessary Wayleave confers only those rights over land. It does not confer planning permission or other development consent that may be required for a particular development project. Importantly, and in contrast to voluntary Wayleaves, necessary Wayleaves granted under the Electricity Act are binding on future owners of the land.
Archie decides to wait and see what Tartan Power do. He's still not keen to grant them any rights over his land. Steph is now going to continue with Archie's tale and tell us what happens next.
Well, because Archie is unwilling to negotiate, Tartan Power commenced the process of obtaining a necessary Wayleave. They do try some pre-action engagement with Archie in a last-ditch attempt to avoid having to make a formal application to the Scottish Ministers. This, as you might expect, is unsuccessful. Tartan Power has no choice but to make an application for necessary Wayleave. Because what they want to do relates to a new electric line, they must firstly serve a notice on Archie requiring him to provide the required Wayleave within the period specified in the notice, which must be at least 21 days. Once they do this, Archie has three options. You can grant the Wayleave on the terms requested by Tartan Power or attempt to negotiate alternative terms. This would constitute a voluntary Wayleave and no further procedure would be required. Alternatively, Archie can refuse to grant the Wayleave or grant the Wayleave on terms and conditions which differ from those requested by Tartan Power and which are not agreed by Tartan Power. In the circumstances where a landowner opts for options 2 or 3, the licence holder may make an application to the Scottish Ministers for necessary Wayleave. This can be made until the period specified in the notice has expired. Any application made before the 21-day period or any other longer period in the notice has expired will be rejected, but there is no upper time limit for submission of an application for necessary Wayleave.
Archie digs his head in the sand and, against the advice of Annie and his solicitor that he should at least try to negotiate with Tartan Power, he refuses to grant the Wayleave. What happens next?
Well, as you probably guessed by now, Tartan Power will wait until the 21-day period has expired and then carry on with their application for necessary Wayleave. They submit this in the relevant form prescribed by the government with the relevant supporting information.
Are the Scottish Ministers obliged to grant the necessary Wayleave?
No, they must be satisfied the Wayleave is either necessary or expedient for Tartan Power to install and keep the electric line installed. Evidence as to what will be required and what is relevant is very site-specific. For example, the effect of the electric line and apparatus in question on farming, both crops and livestock, on the use of machinery, on flora and fauna, and in the case of an overhead line, on the outlook from the building on the land in question, will all be relevant. The Scottish Ministers will also give Archie the opportunity to be heard before granting the Wayleave. They can't determine compensation or rent payable for necessary Wayleave, and this would have to be determined by the Lands Tribunal if agreement cannot be subsequently reached between the parties. At the moment, the Scottish Government is estimating the timescales for getting this application to be approximately 9 to 18 months, and this may make electricity providers more open to negotiations on a voluntary solution. If the rights are granted by the Ministers, they can be for up to 40 years, but this may be shorter in certain circumstances.
And I guess you're going to tell us that the Scottish Ministers grant Tartan Power's application.
I'm afraid so. Much to Archie's dismay, necessary Wayleave is granted. Archie attended the hearing that the Ministers held and put his points forward, but to no avail. He was not willing to instruct Annie or his lawyer to attend on his behalf at the hearing, as he is aware that everyone who participates in the necessary Wayleave process is expected to cover their own expenses.
How is Archie informed about the decision?
He's advised via a letter, and because the Ministers have granted the Wayleave, the Wayleave document itself is also sent to him.
Archie isn't happy, but ultimately accepts the decision. He just wants an easy life and goes back to running his farm and his holiday lets business. Luckily, Annie is able to negotiate compensation on Archie's behalf, as he has no desire for further litigation. Unfortunately, this isn't the end of Archie's tale. But things have been going well ever since Archie's encounters with O3 and Tartan Power, and he has been enjoying the bonus of an annual payment for the Wayleave. Archie decides to buy a neighbouring field for more holiday lets. He is not aware of any Wayleaves on the field. When constructing an outdoor pool for his holiday lets, Archie encounters an underground electricity cable. Luckily, the cable is well protected, so he doesn't hurt himself, but Archie is concerned. He stops work in order to think about his options. Having gone through the process, he knows that utility companies need to get a Wayleave if they want to go through your land. Archie remembers that necessary Wayleaves, unlike voluntary Wayleaves, can run with the land, but the seller did not disclose either any necessary Wayleaves which do run with the land or voluntary Wayleaves which do not to him when he bought the field. If Archie had been aware of these, he would have asked either his solicitor or Annie to deal with them on his behalf when he bought the land. Sure enough, the previous owner of the field had entered into a voluntary Wayleave agreement with the electricity provider. Archie's lawyer was not made aware of this when purchasing the property, and the Wayleave was not assigned to Archie. Archie is concerned that he will have limited legal protection if something goes wrong with the cable, as it is the Wayleave agreement that formally places obligations on the company. Indeed, it almost did go wrong for him during his excavations. Archie has equipment running across his land and no agreement in place to say what his responsibilities are. Not only that, but he has been missing out on compensation, as he has now owned the farm for 3 years without a wayleave in place for the pipe. Archie decides he wants to find out what his legal rights are in the situation and goes back to his lawyer. Steph, what advice is Archie given?
Well, Archie's lawyer tries to persuade him to negotiate with the electricity company, but Archie is having none of it. He instructs his lawyer to serve a notice of removal on Tartan Power in relation to the underground electricity pipe. Tartan Power then has 3 months to A. remove the equipment, B. agree a voluntary wayleave, C. apply for a necessary wayleave, or D. apply for a compulsory purchase order. On receiving the notice of removal, Tartan Power goes back to the Scottish ministers, following the same procedure as before, and obtains necessary wayleave. Archie cannot reach an agreement with Tartan Power regarding compensation, so the Lands Tribunal has to determine suitable ongoing compensation, with Archie receiving a lump sum and regular periodic payments. Archie, though, wants compensation for the period the pipe was on his land before the necessary wayleave was granted, so goes to speak to his lawyer again.
That is where the case of William Tracy Limited against Scottish Power Transmission plc comes in, and Steph will tell us more about that. The decision in this case only came out in January this year.
William Tracy is a recycling and waste management company. It occupies some land in Linwood, Paisley since 1997 and owned it since 2006. It found itself in a similar crossing William Tracy's land, but no wayleave in place. These cables were owned by Scottish Power. Scottish Power had installed these and maintained them in accordance with a voluntary wayleave agreed with the previous occupier of the lands. However, when William Tracy began to occupy the land in 1997, Scottish Power had failed to arrange a new wayleave. In 2005, when William Tracy was in the process of buying the land, Scottish Power got in touch seeking a new voluntary wayleave. Some negotiations followed, but ultimately they broke down with no agreement in place. Importantly, Scottish Power did not then apply to the ministers for necessary wayleave. 5 years later, in 2010, William Tracy issued a notice of removal to Scottish Power, demanding they remove the cables. In response, Scottish Power applied to the ministers for necessary wayleave and were successful. However, this still left the period from 1997 to 2010, during which the cables had been in place, but there had been no wayleave in place. William Tracy argued this was unlawful encroachment on its land and claimed over £6 million in compensation from Scottish Power. Ultimately, William Tracy was unsuccessful in this claim. The court agreed the wayleave ceased to be in place when a change of ownership occurred in 1997, but they found it still remained in effect until the notice of removal had been served. This distinction between the wayleave being in place and in effect is not one that can be found explicitly in the statute and appears to be based more on practicality. The court found that Scottish Power, as the licence holder, had a licence to install the equipment and was doing no more than carrying out its statutory obligations. Further, the statute, in this case Electricity Act 1989, provides an option for the landowner to issue a notice of removal. It also lays out the process following this. The court held that, although the statute does not explicitly say so, this process must have been intended as the only option for landowners, and it wouldn't make sense if there was also an alternative to do nothing and seek compensation several years down the line. Although in this instance the landowner wasn't successful, the case at least makes it clear what Archie's options are if he finds that electricity company has apparatus on his land, but there is no wayleave in place. You'll see the most likely option of serving or issuing notice of removal is that you may end up with a wayleave in place anyway. However, as you've explained, this is perhaps more preferable than having expensive and potentially dangerous apparatus on your land with no agreements in place. It also means you can agree compensation and each party is clear on their rights and obligations. With this in mind, though, it would perhaps have been better for Archie to seek to negotiate with the company before going to the expense and hassle of issuing the notice of removal. Emma, does Archie live happily ever after?
Well, Archie has no desire to enter into any further litigation, that's for sure. However, he is keen to know what he needs. It's now some years since O3 first approached Archie to install the first lot of telecoms apparatus on his land. Archie should ensure he regularly checks with or his solicitor if leave agreements. After be altered or being updated. This can mean that the landowner is not receiving the full amount of compensation they are entitled to, and there could be an argument for renegotiating some of the terms to take account the increase in the burden. But this may depend on the terms of the Wayleave agreement, which should always be checked.
So that's a run through of what Wayleaves are and some of the issues that might arise from the perspective of landowners. In summary, the key piece of advice to landowners is to always remember that you do have rights in this process. A company that approaches a landowner may well ultimately have a right to install their equipment, but you can often come to an arrangement on the terms that suit you as well as them.
It's worth stressing the importance of seeking advice early on, either from your land agent or solicitor. Utility companies have certain rights and responsibilities, and it can be to the benefit of both parties to seek an amicable agreement as quickly as possible.
We have a couple of minutes for questions. If anybody has any, please feel free to tick them in the box on your screen and we'll try our best to answer them. No questions coming through? Okay, that's all we have time for at the moment, but we'll follow up on any questions you want to send us to after the webinar, and both our details are on the screen there. The next webinar on rural crime is on 25th of May, and the private sector tenancy reform webinar from 2nd of June, and we hope you can join us then. Thank you very much.
Thank you.